may lead to a state of public emergency. We have taken note of the reasons given in invoking Article 31. We sympathize with the victims of all these unfortunate events, but also note that there is yet to be issued a conclusive, publicly available information regarding the outcome of the investigations by the police with respect to the unfortunate events leading to the invocation of Article 31. For this reason, we think that the executive should have been slow to invoke Article 31, despite such power being given to the President under the Constitution. We have noted concerns on whether a proper quorum was formed at the National Assembly when the declaration by the President was approved. We have noted media reports that an action has been brought before the courts to determine this issue. We are therefore unable to comment further as this matter is now sub judice. What is the difference between Article 30 and Article 31? Stretching from pre-independence times, emergency powers, whether threatened or actual, were contained in the same article of the Constitution. From the Orders of Council to the Independence Constitution until the 1973 Constitution. When the Constitution underwent an overhaul with the Mvunga Commission, which reintroduced multi-party democracy, the power to declare an actual state of emergency and the power to declare a threatened state of emergency was split into two separate articles in the Constitution. Article 30 on an actual state of emergency and Article 31 on a threatened state of emergency. This has implications as to the different powers under Article 30 and Article 31. What, if any, emergency powers can be invoked under Article 31? By comparison, Article 30, which relates to a full state of emergency, provides full emergency powers, including the power under Article 25 of the Constitution to derogate from the rights in the following articles of the Bill of Rights. 1. Article 13, the right to personal liberty. 2. Article 16, the right to protection from deprivation of property. 3. Article 17, protection for privacy of home and other property. 4. Article 19, protection of freedom of conscience. 5. Article 20, protection of freedom of expression. 6. Article 21, protection of freedom of assembly and association. 7. Protection of freedom of movement. 8. Article 23, freedom from discrimination. And 9. Article 24, protection of young persons from exploitation. The power to derogate from these rights in the Bill of Rights does not exist under Article 31, which relates to the threatened state of emergency. Therefore, all the powers under Article 31 must be exercised in compliance with the Bill of Rights. Reference has been made by the government to the powers under the Emergency Powers Act and the Preservation of Public Security Act. Section 3(1) of the Emergency Powers Act provides that whenever an emergency proclamation is in force, the President may, by statutory instrument, make such regulations as appear to him to be necessary or expedient for securing public safety, the defense of the Republic, the maintenance of public order, and the suppression of mutiny, rebellion, and riot, and for maintaining supplies and services essential to the life of the community. Section 2 of the Emergency Powers Act defines emergency proclamation as a proclamation under the Constitution that a state of emergency exists. In other words, as is the case here, where only a threatened and not an actual state of emergency has been declared, the Emergency Powers Act does not apply to a threatened state of emergency. Whether or not the Preservation of Public Security Act applies is more open to interpretation. The Preservation of Public Security Act was enacted in 1960, so prior to independence, when only the pre-independence orders in council were in effect. Section 3 of the Preservation of Public Security Act states as follows: the provisions of this act shall have effect during any period when a declaration made under the Constitution has effect. The Preservation of Public Security Act does not clearly state what kind of declaration it is referring to. As you can see, there would have been no difficulty in interpretation where the emergency powers were contained in a single article of the Constitution, but it presents a challenge when they're split into two articles, that being Article 30 and Article 31. A reading of Article 7 of the 1965 edition of the Constitution, under which the pre-independent state of emergency was extended post-independence, appears to suggest that the Preservation of Public Security Act only applies to cases where an actual state of an emergency is declared. This is a question that would also have to be conclusively determined by a court of law. However, in LAZ's view, even if the powers under the Preservation of Public Security Act are applicable to a threatened public state of emergency, because the powers under Article 31 do not provide for a derogation of any rights under the Bill of Rights, which we have listed above, powers under the Preservation of Public Security Act must be used in conformity with the provisions of the Constitution, that is the Bill of Rights and any other provisions of the Constitution. We understand that the government is promulgating regulations on measures to be taken. We plan to engage with government on some of these issues. In the interim, we urge the public to be calm and to be comforted by the fact that even during this time, the courts have the power to oversee the exercise of executive and police powers to ensure that such power is exercised lawfully. We also urge the police to speedily investigate the unfortunate events that led to the invocation of Article 31 and keep the public informed so that as soon as possible we can return to a situation where the proclamation under Article 31 ceases to exist and to remove the current anxiety on the implications of invoking Article 31. Number 2, duration of the declaration and resolution under Article 31. Article 31(2) provides that a declaration by the President under Article 31 ceases to have effect on the expiry of 7 days from the date that the declaration is made, unless before the 7 days the declaration has been approved by the National Assembly. In this case, the declaration continues to have effect, having been approved by the National Assembly, subject of course to the court action we referred to previously. Following such approval, Article 31(5) provides that the resolution of the National Assembly will continue in force until the expiration of a period of 3 months, commencing with the date of its being approved until it's revoked on an earlier date. We note anxieties regarding how long the declaration of threatened state of emergency can last. This, in our view, cannot extend beyond 3 months, as there is no power of extension under Article 31, as distinct from the powers to extend that are available under Article 30, which relates to an actual state of emergency. In summary, President Lungu had the legal discretion to invoke Article 31. However, the question as to whether the circumstances cited for invoking Article 31 were justified can only be conclusively determined by a court of law. The government does not have full emergency powers under a threatened state of emergency. Any powers exercised must be used in accordance with the Constitution, and in particular, in accordance with the Bill of Rights. Finally, the government has no powers to extend the threatened state of emergency beyond the 3 months approved by Parliament. Thank you.